Happy day to all. In today's session, we will deal with the subject Advanced Corporate Accounting, Unit 2, Liquidation of Companies. The agenda of coverage is as follows. We will reflect on why entities enter into liquidation, what are the situations that force them into liquidation, what are the governing legislatures with specific focus on India, definition of winding up and the modes of winding up as prescribed by law, the statement of affairs, order of priority of settlement and other operational procedures in conjunction with law and accounting as prescribed by the legal framework. So, while every company is born, every entity rather, it could be a sole proprietorship, it can be a partnership firm, it can be an LLP or a company. Any entity when born, it is incorporated with a set purpose as defined in its memorandum and articles of association or a partnership deed. And it is also established with the expectation that it will continue for the foreseeable future for a significant period of time. In accounting parlance, this is called going concern. But on the way there, in the path, the companies or entities do face quite a lot of hiccups while dealing with their day-to-day transactions. And the ones that are significantly troubling is what lead to a situation called winding up or liquidation. Now, it is possible that an entity and its directors on their own accord decide to cease the operations of the entity. This is possible when the objectives with which the entity was established are completely satisfied, or there is no next generation leadership or succession that is willing to take forward the business of the entity. So, in this case, the entrepreneurs or the founders or promoters decide to call it a day, and whatever assets or wealth the company has earned so far will be distributed among the stakeholders in the order of priority of claims. The third situation is where the company or entity is in financial distress. Ideally, it should not have been brought to this stature, which is why every year on a regular basis, the company publishes a report card. Report card meaning profit and loss account and balance sheet, where the shareholders are given assurance that the wealth and the operations of entity are smooth and clean. It is also the responsibility of a company secretary and an auditor, and by default the directors and management, to pick up on the signals of financial distress. These are done with the tools of management accounting like trend analysis, common size, comparatives, more importantly ratio analysis, where the numbers would throw up if the company is overburdened with debts that it cannot satisfy. So, ideally, it should not have been brought to this situation, and a discussion should have been there between the lenders and the entity on how they can best sort out the financial distress, and they will come up with something called corporate debt restructuring. This is similar to what the consortium of banks led by I think SBI tried to achieve for United Breweries, which is Vijay Mallya's company. And unfortunately, that was not quite successful, and we now have Vijay Mallya on the run from India, and he is going to be tried in courts abroad or in India. So, coming to the governing legislature, every society needs law to give some order and accountability to its public and national interest. So, the Ministry of Corporate Affairs is what oversees the functioning of every registered entity in India. Now, we have two applicable laws. The first one and the original one being the Companies Act 1956 and now the Companies Act 2013. Chapter 20, ranging all the way from sections 270 to 375, deal with winding up of a corporate entity. And the more recent is the Insolvency and Bankruptcy Code of 2016, which was introduced for a more specific purpose, which we will explain later. Both these are laws that are to be implemented through agencies appointed by Ministry of Corporate Affairs. There are primarily three agencies. The first one is the Registrar of Companies, and the second one is the Insolvency and Bankruptcy Board of India, and the third one being the National Company Law Tribunal. All three agencies are entrusted with the activity of overseeing the corporate functions of every entity registered in the country. So this is a snapshot of what the Companies Act covers. The part 1 is winding up by a tribunal where the ROC says it is time for you to shut shop. Part 2 deals with voluntary winding up, and this is where the company on its own accord is saying, no, I am done. The part 3 is common provisions for all modes, which are general procedures applicable whichever mode of winding up the entity might choose. And the fourth part is official liquidator. A liquidator is a professional appointed by the court or the appellate tribunal in charge of overseeing the liquidation proceedings of every entity. And this is what the IBC 2016 in a snapshot. So these are the key chapters that I would like to bring to your attention. The IBC was introduced as a common act that governs the resolution process of all the entities, whether it be a company or a partnership or a sole proprietorship. A key point of distinction between Companies Act and this, while the Companies Act covers only companies, corporates established in India, the IBC covers all tiers of entities, whether it be a partnership or a corporate or a sole proprietorship. Now, Chapter 1 deals with preliminary terms and conditions. Chapter 2 is insolvency, resolution and liquidation for corporate persons. Out of this, Part 2 has been the crux of this act and predominantly why this act has been very successful since 2016. Corporate insolvency resolution process. Earlier, when a company filed for winding up, it was a very long drawn process to go to court, get it resolved and then distribute the assets to the balance claimants. By the time this procedure is complete, the shareholders and the stakeholders are quite tired and they would just settle with whatever comes from the company. But this cannot be the way we continue to function. So, IBC was primarily incorporated with an idea that given a deadline, every insolvency and liquidation procedure should be complete within the set deadlines so that all stakeholders get their dues. Chapter 3 is liquidation process. Chapter 4 is fast track insolvency process and Chapter 7 is offences and penalties for not complying with the deadline set as per the IBC. So coming to the definition and meaning of winding up and liquidation. Winding up is a term used as per the Companies Act, while liquidation is a term used in IBC. So it mainly refers to the legal process by which a company is dissolved. The assets of the company are basically realized or sold and the money realized from that is used to distribute it to the creditors and the claimants of the company and finally the preference and equity shareholders. Why? Because these shareholders have taken maximum risk, they agreed to take maximum risk and they are entitled to only residual interest in the company. A liquidator, as mentioned before, is appointed and entrusted with the following duties. He is in charge, he or she is in charge of liquidating all the assets and keeping account of each and every asset so liquidated and the money realized from that. Now, using those funds, the liabilities of the company are to be paid off. Suppose there could be a situation at this stage where the assets are not sufficient to cover the liabilities of the entity, which is why in the first place a financial distress signal is thrown up. So, in this case, what do? The shareholders have limited liability towards the company. So, in case of a deficiency, the shareholders will be called up to pay a certain amount, that is their uncalled capital, to raise further funds for settlement of liabilities. And lastly, they have to apply to the registrar of companies to remove the company's name from the register. Now, these are the primarily A and B are the significant modes of winding up that are mostly followed today. The first one is by the court or tribunal, otherwise called as mandatory or compulsory winding up. And the second mode could be voluntary winding up, where members or creditors of the company themselves file a petition for liquidation. So, when does the court or tribunal instruct that this company has to be liquidated? It would be a result of a series of non-compliant actions or violations that have been perpetrated by the company. It could be that the company has not filed its financial statements or annual returns with the registrar every year. and at least for the past 5 years it has not been compliant, and the company does not commence business within 1 year of incorporation. Ideally, the minute the company is incorporated, it is expected to commence business activities. So then, when it is not commenced for 1 year, it means there is something wrong or there is some hiccup that the company is facing which needs inquiry. The third one is the company is unable to pay its debt for a significant period of time, or the number of members that are minimum required for a public limited or a private limited entity, being 7 and 2 respectively, are falling short, which means the company cannot be registered as a public limited anymore and it has to be dissolved. The trade of the company or acts of the company have been against national interest. Many a time we find that there are shell companies or false fronts that are projected. A company is just incorporated on paper and it serves as the front for many illegal operations at the back end. Once such companies are brought under the scanner of the CBI or the national governing agency, then at any time they face the risk of liquidation. So, any activity that the company carries on against national interest, the court shall order a mandatory winding up of such an entity. Or lastly, the court finds any other equitable and just grounds to liquidate the company. These are the situations where the court itself shall order the winding up of a company. Coming to the second mode, voluntary winding up. Voluntary winding up is a scenario where the corporate person does not have any defaults or has not violated any terms prescribed by the ROC, but on its own accord is willing to initiate winding up proceedings. Majority of the directors have to in unison declare insolvency. Declare insolvency can happen only when either the company has no debt or it does have debt but the company has the capability to pay it off immediately or at least within 3 years from the time liquidation proceedings have started. But before declaration of insolvency can happen, a thorough inquiry into the affairs is ordered by the ROC before filing for insolvency. But once it is filed, then a special annual general meeting has to be organized by the entity where they pass a special resolution in the AGM and an insolvency professional is appointed within 4 weeks of filing for insolvency. Creditors who represent at least 2/3 of the debt owed by the company have to agree and approve within 7 days of such special resolution. Only then the company can proceed for filing of winding up. So, a petition other than the court being ordering the company to wind up, the owners of the company also have a right to petition for compulsory winding up of the company. Any shareholder who has held shares in the company at least for a period of the past 6 months is entitled to petition the court that such and such company for so reasons has to be wound up, in my opinion. Or the registrar, after obtaining permission from the central government, can file a petition for winding up or by the company themselves. Now, coming to the operational aspects of a winding up. Once all these legal procedures are settled, then we start with preparing the statement of affairs. Statement of affairs is basically a document that states that the company as of today, as of the time from which liquidation proceedings have started, has the following assets, okay, which are encumbered, not unencumbered, and statement of affairs is basically like a report card through which the directors declare that the company as of today has so many assets which are pledged or not pledged and from which I propose to settle the following liabilities. So, statement of affairs has to be prepared in this designated order and which will be overseen by the liquidator. Let us check out the components of statement of affairs. It is comprised of list A through H. List A asks for the list of assets that are not pledged to any specific creditor, which means all such assets are available for distribution to all the claimants. List B tackles assets specifically pledged to creditors in either partial or full settlement of their dues, which means, for example, if we take plant and machinery, one particular creditor or bank has given me a loan in exchange for asking for this plant and machinery as security. So in the event the company defaults on this loan, the bank is entitled to take possession of such asset, liquidate it and realize their dues. So that is what is meant by specifically pledged. Third is list of preferential creditors and amounts due. Fourth is list D, debenture holders with a floating charge. Floating charge means there is no specific asset that is encumbered. It is a segment of assets that is given to the debentures as a floating charge. The value of such charge is dynamic, which means if I say the current assets are pledged towards the debenture holders, current assets comprises of stock, debtors and other current assets. So in the situation where the stock value is insufficient to cover debenture holders, the debtors can be used to settle their claims. So that is called a floating charge. E. Names of unsecured creditors and their amounts due. List F. Names and holding of all the preference shareholders. List G. Names and holding of equity shareholders. So this is basically the components of the statement of affairs. Now while preparing the SOA, these are a couple of key points to be noted which we can deal with as we progress with the problem solving part of the chapter. There is a certain order in which the payments are to be made, and this is the order. The first one being overriding preferential payments. What are overriding? They take first priority and top priority amongst all others in this list. If you see, the breakup of overriding preferential payments would be salaries and wages that are due for more than 2 years to your existing employees and staff, leave travel concessions or paid holidays that are pending from the company's side, any staff provident fund contribution or pension fund that has been established which has not yet been paid to the employees, or lastly gratuity. So these are the subcomponents or key categories of overriding preferential payments which take priority over any other segment here. So the next comes secured creditors. The third is cost of liquidation. So cost of liquidation has again 3 components. The first one could be the court fees that is payable when we file legal documents. The second is the liquidator's remuneration himself, and the third one is cost of liquidation. After this comes preferential creditors. Again, if you see, these are the preferential creditors who are entitled to payment after secured creditors. So you have government taxes, salaries and wages that are currently due, contribution to employee state insurance, compensation in respect of death or disablement of an employee while working if they have been subject to any occupational hazard, then that settlement is to be settled before any unsecured creditors. So and then expenses of investigation that has been run by the registrar of companies. So all these take priority in this order. The next coming debenture holders with a floating charge, and then unsecured creditors, and lastly preference and equity shareholders. So after realizing the assets, this is the order to follow mandatorily. Lastly, the liquidator is supposed to prepare his final statement of account. The pro forma entries in this account will look as follows. The first one being 2 assets realized by liquidator's remuneration, liquidation expenses, debenture holders who are entitled to principal and interest due by unsecured creditors, preference shareholders who are entitled to their capital, any premium and any arrears of dividend that are due to them, and lastly residual interest to equity shareholders if available. And as discussed before, if it falls short, then the equity shareholders will be called upon to pay the remaining of their unpaid share capital, and that reflects on the debit side of the liquidator statement of final accounts. So that brings us towards the end of this chapter. Thank you.